Hey guys, let's talk about the motion to compel that Marilyn Manson has filed against Ashley Walters in the Bianco case for failing to show up for her deposition or to produce documents that he requested. That was filed last night. It contains the arguments of both parties. It's just the way it is these days. Courts don't like to hear discovery disputes, so they have all these roadblocks before you get in front of them over one, including that they have to meet and confer, they have to do some telephonic conference and alert the court of that, try to achieve a joint stipulation, and eventually, finally, the motion to compel comes forward and the parties can settle their differences on this discovery matter. So what is it? She was subject to a subpoena, and an attorney can issue a subpoena in an action and compel the attendance to a deposition of a non-party to a case, provided that person is subject to the jurisdiction of the court. So first of all, well, what if I have a witness in North Dakota who knows that I didn't cause this car accident and I'm in North Carolina? Can I force them to set for a deposition in North Carolina just by issuing a subpoena? No. The court can only do that within its geographical jurisdiction and jurisdiction over the person. So if I issue a subpoena in North Carolina to somebody in North Dakota who has nothing to do with North Carolina, it doesn't mean anything. So if I wanted to take that person's deposition, I would have to go to that state and use the court there under agreements that the states all have with each other for the most part that would allow me to get a subpoena there and cause the person to testify there. I can't make them come here. But because some people have asked me, well, could you really have to show up if somebody issues a subpoena? It depends on the subpoena. But if you live in the jurisdiction of the court and you're there and you get served with it, yeah, it's not an option. The subpoena doesn't say if you feel like it, show up and answer these questions. It's an order of the court. And that's what was done in this case for Ashley Walters. It was served allegedly on August 9th. And the parties debated dates and scope of the deposition. And her attorneys felt like that what Manson was asking for was too broad, document-wise, and potentially topics where she would have to testify. They didn't want that to happen. They couldn't reach an agreement on it. The day came and went when she was supposed to set for deposition. So now there's a motion to compel. So let's talk about what that is. So in theory, if you receive a valid subpoena and you think it's unduly burdensome, overly broad, fishing expedition, requests information you shouldn't have to give, your option really is not supposed to be, well, then I just won't show up for it. How about that? I just won't obey this order. You are allowed under Rule 45, which is the rule the subpoena is issued under, to ask the court to limit that subpoena or to quash it altogether or to make what other order is necessary to make compliance reasonable. Maybe it's expense, maybe it's scope or whatever. You're supposed to do that before the time of the deposition. You're not supposed to ignore it. So remember, when Smithline was supposed to show up for her deposition, her attorney, Ellwanger, when he decided to withdraw out of the case, he did file a motion to quash and modify the subpoena before the deposition. And that's how you're supposed to do it. Manson's attorneys argued that he didn't do it timely because it was so late. But Ellwanger's position is, hey, I just withdrew out of the case. These guys knew that. We were all just finding this out. I filed it as fast as I could. So he followed the procedure you're supposed to file. In this case, Walters didn't do that. She didn't file a motion to the court for protection or to modify the subpoena. She just argued with the other side, and eventually the day came and went. So is that going to end up mattering? Well, we'll look at it. So with the situation being at a stalemate, Manson's attorneys filed a motion to the court saying, hey, she was issued a subpoena. She didn't file any objection to it with the court, and she needs to be ordered to show up and testify and to give over this reasonable scope of documents. So the motion to compel has three issues that the parties are disagreeing on. One is the scope of production of documents that Manson's requested. Second, the scope of the deposition that he's requested. And third, whether either side has to pay the other side for having to go through this whole motion to compel. So let's look at the first one, which is the documents he wants. So the document request was entirely this: all written communications with Esme Bianco, Evan Rachel Wood, and or Ashley Gore, aka Ilma Gore, regarding Brian Warner, including but not limited to text messages, emails, social media messages, and any other direct messages. So the documents Manson requested was just that, nothing outside of that. So in other words, communications with three people that had to do with Manson. So if they were talking about something other than Manson, he didn't ask for it. If there was a fourth person she was talking to, he didn't ask for it. These three people. So her attorneys argue that this is too broad, that this is outside the scope of Bianco's lawsuit, that this is just a way to try and get information that could harass other people. It's also overly burdensome. I mean, she has to track down all this information and find it. And some of it may be confidential in nature. I think those are kind of the three objections. So the confidentiality part, Manson's attorneys rebut and say, look, there is a confidentiality order in this case, and you are allowed to use the provisions of it. And no, you don't get to just not show up at a deposition or turn over documents because you think people shouldn't see what's in it. The court can protect you to some degree, but it's not a voluntary system of compliance where I really don't want to show people this stuff, so I just won't. That's not a solid argument. And they make, fortunately, better arguments than that. But Manson's come back that there is a protective order is a good one. The other argument is all overly burdensome because he doesn't limit the time and it's all these people and all that. Come on. It's 3 people, right? 3 people. And don't forget that Walters sued Manson and her case was thrown out, but it's on appeal. So before she sued Manson, she didn't look over her own evidence that involves the people involved in the case and gather it for her attorneys. Really? This is so burdensome for her? Because, you know, if her case gets reinstated, she's going to be deposed and all this stuff would be subject to the deposition anyway. So I think that argument is kind of ridiculous. The argument it has, if there is any teeth to it, that would have any teeth to it, would be the one that, and this is more than what's appropriate for this lawsuit, that what does Ashley Walters having said to Ilma Gore have to do with Bianco unless it involves Bianco, even if it involved Manson. And Manson says, look, the central tenet of our defense is that these people got together at a survivors meeting and coordinated before and after that to come up with similar allegations. And they all filed these lawsuits in short order against him at around the same time, I suppose, they were making these criminal complaints. And of course, when the documentary cranked up and all that. So he's saying that these are the central characters of this conspiracy that was used against him to gin up all these lawsuits to try and overwhelm him and force him into settlement and destroy him and stuff. I mean, I think they even said in the documentary they wanted to destroy him. So to me, it's not a fishing expedition because it's just 3 people and only what they said about Manson. I get it. You may have a different opinion because you think, why should Manson be allowed to get any information from these women? Okay. If that's your position, that's fine. Okay. My position is when you're in a civil lawsuit and you're in discovery and you have information that supports either side's ability to make their case or defend themselves, you're supposed to turn over that information. This doesn't ask for her personal history. This doesn't ask for her communications, all her friends and families. It doesn't even ask for any communication she had with anybody about Manson, only about these 3 people. So in my opinion, Manson should win this side of the document fight and get these documents. That's my opinion. You can have a different one if you want to. One thing we can agree on, it doesn't matter whose opinion is what, because the court will end up deciding it later in October. So the second issue is the deposition itself. And there are some similar arguments made there that this is a fishing expedition, that there'll be private information disclosed, that it's too wide-ranging. And Manson makes the point that, it's not up to them to just unilaterally decide we can only ask questions on a very narrow subject. And in my understanding of the law and practice over decades, that his reading of that is correct. But hidden within all the arguments, her side makes the case that we should at least know what the topics are, right, that are coming up in this deposition. She's a non-party. She shouldn't be exposed to the full range of potential discovery that a party could be because she's just a witness in this case. And then if we knew the general topics, then we could say we object to this topic or we don't object to any topic. And I am sympathetic to that aspect of what they're saying. I could see the court saying we're going to order you to come to the deposition, but we're also going to order the subpoena to be modified to lay out the topics that will be covered. That way she doesn't have to prepare for anything under the sun. She doesn't have to worry about her own personal history, etc. And if the deposition were limited to some degree closer to what the scope of the requested documents are, then that would be a narrower deposition, certainly, right? So I don't think she's going to get everything she's asking for, but I could see her winning the point that the general outline of the subpoena should be given so that she can either object to specific things or show up and go ahead and testify to everything. And then they wouldn't have a further dispute with the court. So I could see that happening. And the last topic is, should anybody have to pay the other side for this? So under Rule 45, a party or a person can be held in contempt if they fail to comply with a subpoena. And when non-parties don't comply, people have argued many times that, hey, court, you're allowed here to award expenses, but it really doesn't happen that way. Then under Rule 37, when you get a motion to compel, there's also clauses in there for awarding expenses or sanctions against people, parties, and non-parties who don't comply with discovery. But generally speaking, if you're a non-party and you're kind of making a good faith argument to the other side about what's going on with discovery, it's often the case that the first one is free, that the court's going to say, okay, we're going to order this. Okay, you're going to have to comply with the subpoena as it's drafted, or you'll have to comply with the subpoena, but it has some limits on it, and we're not awarding anybody's costs at this point. And I think that's most likely the outcome there. So I think nobody wins the third point. On the second point, if I were the judge, I would probably grant some of what Walters is saying here. That's my position. On the first point about the documents, I would completely come down on Manson's side. So it's going to be argued in late October, and the court will make a decision at that point and move forward. So that makes, as it currently stands, Walters has been subpoenaed to testify, and she hasn't shown up. Smithline has been subpoenaed to testify, and she hasn't shown up using the fruit bat defense, which is it's fairly novel. It hasn't been to the Supreme Court yet, but it is interesting. Wood was requested to come to deposition. She doesn't want to do it. That's going to be heard next week prior to the anti-SLAPP motions. So that leaves Bianco, who I'm not aware has been asked to testify, and the Jane Doe, who I don't think has been asked to testify yet either. But the three who have been asked to testify, nobody has shown up yet. So we don't know when their stories are subject to cross-examination from the other side, what they're all going to say. Now, when these depositions do occur, then what happens? Do you get to read it? No, these aren't public documents that you're just going to get to see. If you see them, it'll be because somebody leaks it, or it'll be because it gets applied to a court filing, that somebody makes a motion and includes part or all of the deposition in it. But even if that occurs, because in the Bianco case, there's a confidentiality order, there's a good chance that a lot of the things will be redacted out of any public filings and you won't know what they said. For example, the motion for sanctions that's going on right now in the Bianco case, that's all under seal. And even in this motion to compel, part of the brief is redacted and things are marked out as the parties are trying to comply with the confidentiality order that's applicable in this case. So that's what's going on with the motion to compel and what's happening with it. And that's all that's going to happen for this week. Next week is a pretty big one because that's when the state court case of Manson against Wood Gore will hear whether and decide, hopefully, whether Manson gets limited discovery before the anti-SLAPP motions are heard. And that's mid next week, I think. So we'll see what happens on that. All right, before we end this, we're going to do something we haven't done before, which is have a little Q&A session, because although I think I explain things clearly, that may not actually be the case. I may have a little reality distortion field there. So I have an average reasonable person who's just listened to all the stuff I said and has some questions about what I meant. Like, what does that supposed to mean? What did you mean by that? And let's see what these questions are and if we can clarify some of the things that I said earlier. All right. So what's the question?
Who's the non-party to this case?
So who's a non-party? So I've been throwing around the term non-party. So a non-party is basically everybody on the planet who isn't a party to the case. So a civil case is going to have a plaintiff, one or more. That's the person who brings the lawsuit and has the claims. It's going to have a defendant, one or more. And that's the person who's being sued, right? Sometimes you can have cross claims and other defendants and things like that. But basically speaking, you're going to have a plaintiff who files the lawsuit and a defendant who's responding to the lawsuit. Other people are non-parties. We're all non-parties to this lawsuit unless you're in it. Now, sometimes a non-party can be a witness to a case and have relevant information to a case, but they're still a non-party to the case. Good question. So that's a good question. And sometimes people say, well, if you're going to have a deposition, do they have to know the questions first? Do they have to know the topics first? Generally speaking, no. Okay. But I think it's a fair request here that the topics be outlined so that she knows the scope of what she's supposed to prepare for. I think it's fair. So there's not a per se requirement that you have to limit your deposition necessarily. But when the non-party asks for that, especially a non-party to the case, I think it's a fair request, and I think there's a good chance she'll win that.
Would their, meaning Manson's decision not to provide topics in advance, hurt their discovery in their case?
So, okay, so that's a good question, which is if they don't alert her to the topics ahead of time, can that hurt how they're operating in discovery in the case? And it could in this sense. Let's say she did show up for the deposition and you start asking her about a topic and she says, I don't know. I didn't prepare for that. I mean, you didn't tell me anything that we were going to talk about. And I can't spend all my life preparing to tell you everything that's ever happened to me. All I have is my current recollection, unless you've got something to show me. That wasn't anything that I spent any time thinking about. Sorry, I don't know. So, yeah, I mean, you do want the witness to be prepared to testify about what you're going to ask about, especially if it's a non-party in theory, because if don't have a fresh recollection, they can just sit there saying, I don't know, which that's what you want the person to do if you're their lawyer. It's like, I don't know. I don't know. Yeah, you didn't get me ready for that one. Sorry about that. I don't know. So it could in theory also hamper what they're trying to achieve. But of course, she's a hostile witness in reality anyway, so she's not going to be volunteering things to him that she can avoid in the first place. It's not an unbiased, neutral witness. But good question.
What's the required lead time on notice of deposition or for deposition?
So they don't really have per se a lead time, but if you don't give a person a reasonable lead time, then there's a good chance you're not going to be able to enforce the subpoena anyway. But in this case, there's a lot of email exchanges, et cetera. And what Manson's attorneys did do was tell Walter's attorneys, what days are good for you? When can we schedule this? We want to do it in August. And her attorney said, we can't do that. That's way too soon. We'll do it in September. So they ended up picking September 20th, as that was within a small range of dates that her attorney said they would be available. So they did collaborate and choose a date that was acceptable to Walters and her attorneys before they issued the subpoena.
Court compel a deposition.
So the court can compel a deposition. So it is an order, and if you don't show up for it, what happens is what's happening in this case, which is there's a motion to compel on the calendar, and the court's going to tell her, presumably, you need to show up for a deposition. They may change the scope of the subpoena, they may not, but you can compel a non-party to show up for a deposition, and if they don't do it and keep not doing it, they can be found in contempt of court. And contempt of court can range from, the penalties for that can range substantially. They can range substantially. The idea for that is you want to incentivize the person to stop being in contempt of court. So the first thing that usually happens is an award of some kind of fees, punishment to the other side. You're going to have to pay the lawyer's fees for these guys getting ready for the court reporter. I've seen that happen many times. The court has various inherent authority. If it wants to escalate, it can eventually do that. I mean, they put people in jail before for not testifying. So I'm not suggesting at all that that's what's going to happen in this case, but the court has a lot of power when it has jurisdiction over somebody. People like to imagine that they don't, but they do. They're just not supposed to exercise it beyond what is necessary. So they'll range this up. Take, for example, in the Alex Jones case, which does involve a party, but it's a similar situation. When the court found that he wasn't complying as the court saw he should in discovery, they started sanctioning him and awarding fees and things like that against him. And eventually they found that the noncompliance, whether you agree with what they said or not, this is what the court found. I'm talking about the Texas court, and I think Connecticut did the same thing, found his noncompliance severe, pervasive enough that the prior sanctions weren't working. So they struck his defenses in the case. That's kind of the opposite. If you're the plaintiff, they'll throw your case out if you violate enough discovery provisions. So they have a lot of power. I mean, they can just end your case. They can end the defense of your case. They can do lots of things to you. So eventually, you need to comply with what the court is saying.
Well, so the court can sanction or throw out cases to parties to the case, but this is a non-party to the case.
Right. And a non-party can be found in contempt of court too. And so they can be punished financially or other things like that. If they're attorneys, the reason for the unwarranted obstruction, the attorney can be individually sanctioned. Been in plenty of cases where it's typically the sanction is against the actual lawyer because the lawyer's saying, don't answer this question, or the lawyer does something that violates the discovery rule. The party's not really the one at issue there. So I have seen many times lawyers have to write checks to the other side for discovery violations. Now, that's not the status that we're at here. Walter's attorneys are saying, look, we were in negotiations to try and work all this out. That's what we want to do. We want to respond fairly to a fair scoped subpoena. So I don't think, they're in trouble with the court at this point. I think the court's going to work this out somehow. Now, if they were to not comply after that, the situation would, of course, change, and they could be found in contempt at that point. All right, so that's all the questions that we've got from the gallery. And everybody have a good weekend. Thanks. Bye.